Good afternoon, committee members. Welcome to this afternoon's meeting of the Judiciary Committee. As always, we will begin with committee introductions. Would you like to begin us, Representative Sinclair?
Good afternoon, everyone. I'm David Sinclair, here for the people of House District 50, the City of Bath.
Good afternoon. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Hanover, Milton, Roxbury, and my hometown of Rumford.
Good afternoon. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hi, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good afternoon. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Hello, everyone. My name is Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, and some of Scarborough. I serve as the Senate Chair. I will momentarily have to run back down into the Senate.
And I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee. So first, just a brief announcement before we get started. The work session on LD 2168 has been postponed, so we will not be taking up that bill today. But we will begin the work session on LD 2107.
Good afternoon, Eli Murphy, Office of Policy and Legal Analysis. Supi should have, and I know she's chatting with Senator Carney, so I might pass it out. We have a copy of an amendment that you were sent via email. I also am going to pass out some information on, so Supi, there should be the yellow amendment and then a white 2-pager as well. There's also some information provided on other states' nonprofit security grant programs that have both the federal program as well as state programs. We last discussed this bill last week, at which point there was a proposed amendment to make some changes that I will go over once you have those in your hands.
Representative O'Halloran, would you like to introduce yourself when you're done chewing? Sorry.
Good afternoon. I'm Danny O'Halloran from District 20, the industrial city of Brewer.
Great. So some fairly simple changes to this amendment. You should see throughout, there's a change from the Office of the Attorney General to the main emergency management agency, as was discussed. The title of the fund, or I guess the appropriations title has changed as well because it's going to the Department of Emergency Management. The Department of Veterans and Emergency Management departments, the way that the appropriation sections write bits back and forth, it is the Department of Defense, Veterans and Emergency Management. And it's the main nonprofit security grant program. And so the other amendment expressed at the public hearing and at the work session before was changing the appropriation amount from 2 million to 1.5 million. And then there's also new language at the end of that initiative piece stating a portion of allocated funds may be used by the main emergency management agency for program administration. Simply, that is just to allow for the function of these grants, both the receiving of applications and really the process part to function. Beyond that, the text is as you see it. And again, that other sheet you have, those are states that have both a state version of this type of grant as well as the federal grant funds that Maine also receives from the federal government.
Thank you. Are there any questions on the amendment for Eli? Okay, not seeing any. Did you have anything else for us, Eli?
Nope.
No. Right. I'm just noting that we also received this handout, I guess, from the bill sponsor. Would the bill sponsor like to come and join us and offer anything on this additional handout or no?
Thank you, Representative Kuhn. My name is Michael Brennan. I represent District 115, which is part of Portland. And thank you. All I can say about the amendment is we tried to be responsive to the issues that were raised by the committee last Friday in work session. And as Mr. Murphy has pointed out, we've tried to delineate the responsibilities of FEMA in administering it, also allow them to develop routine and technical rules for the administration of the state side of the program, and also to emphasize the fact that it would be available to nonprofits that are experiencing hate crimes or acts of terrorism. In addition, today I just handed out a breakdown of 18 other states that have hybrid programs where they combine federal money with state money to address these issues. And if you look at the map, you can see that, it's a pretty pervasive practice across the country to have states jointly use federal money and state money to address this issue. So I won't belabor the point, and thank you. And I think the amendment is responsive to the issues that were raised in work session last Friday.
Thank you. Are there any questions for the bill sponsor? Not seeing any. Thank you.
Thank you.
Committee members, do you have any questions for anyone else here in the committee room? I see we have a representative from MEMA. Representative O'Halloran.
I think I might have asked this last time, but I have forgotten what the answer was. Is this also based on need? Like if an organization that's nonprofit has more than enough money to pay for their security, do they still qualify to get these funds?
Would you, sir, be willing to come up and answer that question from MEMA's perspective?
Hey, good afternoon, everyone. Joe Legee, Deputy Director for Maine Emergency Management. If I heard the question correctly, it was if an organization already has kind of the financial means, can they still qualify? If they already have money, can they still ask for money for this program? There's not like a financial check to see kind of the fiscal health of an organization to see it. They don't have to prove that they're disadvantaged funding wise to qualify for the federal program as it currently exists. That's not a requirement.
May I ask just one more question?
Yeah.
So let's just say that you have an organization that has a lot of funds and it's a huge building and but they need a lot of the expense to outfit it fully is like a huge amount.
Right.
Do you give them all that or is it capped? Like, will they not get any more than what the ones that don't have the funds to do that?
It's capped. So the current federal program is capped at a total project amount of $200,000. So they would be subject to that cap. Anything beyond that, they would have to do with their own resources for that fiscal year.
Thank you. I
Yes.
think you did tell me that last time, but thank you. Sorry.
Is that the kind of information that would also be developed through rulemaking? Were this to be put into place?
Yes. Yeah, I haven't looked at the amendment yet, but for sure.
Okay. Representative Lee?
I think that answers it, but it's not a threshold, needs not a threshold, but is it part of the consideration of which grants get?
Financial needs specifically. I was just looking through some of the documentation. I did provide some last work session, so I'm just looking through to see if one of the rated areas is fiscal need. I'll say that most of it relates to kind of how good of a job a nonprofit did explaining the project and how it closes a defined risk, as well as kind of what risks they are subject to. I don't immediately see kind of that as a factor that's rated or considered.
And for committee members, the spreadsheet that he is looking at, that was emailed to you. It's a fairly lengthy document, so I didn't print them out for you. But there are two spreadsheets emailed out that are essentially a matrix of the things that FEMA considers when evaluating these applications. And you should have those in your emails from last week.
Thank you, Representative O'Halloran.
I'm curious, and I don't know who to direct the question to, but I mean, oftentimes it's the very wealthy organizations that have the people that are great at filling those out and qualifying for them. Whereas the ones that are on the low end of that spectrum struggle with that. Is there a way to add something in there about their financial resources for consideration, or is that not allowed?
I mean, I think we're open to kind of whatever the intent is, sponsor committee, to kind of help structure that program, and then we'll work within those bounds.
Yeah, it's my expectation too. I think the bill anticipates that there would be rulemaking because the state wouldn't necessarily be bound to exactly the same process and parameters that the federal program would operate under. So to me, that's something that would come up in rulemaking, but
Can I follow up on that too? Is that-
please.
We do also strive to offer technical assistance, specifically in cases like you mentioned, where there are smaller, maybe less experienced applicants for the program. We do workshops. We help them with technical assistance to build out and fill out their applications. The investment justifications and FEMA grants are pretty complicated. So we work with people to kind of fill those out to make sure that they're available to those smaller or more rural kind of customers, not just the bigger, more resourced ones. Yeah.
Representative Caruso, would you please introduce yourself and then go ahead with your question?
I'd be happy to. Thank you. I'm Representative Caruso. I represent House District 72, which is much of northern Somerset County. Thank you for being here. So I'm kind of stuck on this bill where I was the last time. The effort was to mirror the FEMA, the federal funds. And yet it's not, the language doesn't mirror it. This refers to hate crimes, whereas the federal funds refer to domestic terrorism, domestic violence, extremism. Is that accurate?
So I did do in between the last work session and this work session, just some simple kind of keyword searches in some of the grant doctrine for the federal nonprofit security grant program. In the notice of opportunity, the notice of funding opportunity that I believe Eli provided, it does use the word hate a number of times as one of the risk areas that is eligible under the program. So I did find that those terms are shared: terror attack, terrorism, hate-based crime, hate-based attacks are used in the federal program as well.
Okay. But in this particular language, under definitions, under 1A, it's just hate crime. It doesn't talk about domestic terrorism or anything like that. So it's just seems very, very broad. And maybe more than what the goal is of some of those who testified. And how would that prove challenging to your organization? Because it's different than what you traditionally have been doing.
I'm trying to think in kind of this hypothetical environment of how we'd navigate that language in the rulemaking process or otherwise. My initial reaction to that is that the terms are close enough that I don't think it would present any major issues or conflicts with using a lot of the same tools as we use for the federal program. So when I look at this matrix that's provided here, I think most of that's there. And we would have to consider kind of if there are conflicts that we find in that process, kind of adjudicating those through the rulemaking process to kind of define what changes need to be made to the process to accommodate a state program.
Representative Pugh, would you introduce yourself, please?
Thank you, Madam Chair. Good afternoon, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Thank you. Are there any further questions, committee members? Not seeing any. Thank you for being here today. Any discussion, committee members? Or perhaps, do people need a caucus break? Folks seem a little quiet. Trying to give you some options. Representative Caruso?
Thank you. I was actually looking in my files for more of the federal language. I couldn't find it, but I came across the CLAC testimony. Would we discuss this about their notes, like 4 of the 5 crimes identified in the bill for enhanced assessments are already subject to additional.
Representative, I think that's a different bill.
That clock testimony would be for LD
Oh, it was
two
in my
one six
file.
eight.
You're right.
Yeah.
Okay. Thank you. I was wondering how.
I was
that-
thinking, I don't know why CLAC would comment on this bill, but maybe they did. I don't know.
That was testimony for the other bill that was on for this afternoon.
Oh, okay.
Representative Henderson?
Thank you, Madam Chair. Once the discussion here dies down a little bit, I would like to ask for a caucus break.
All right. Before we go for caucus, is there any other information that folks want before they go? Okay, not seeing any. Eli?
I will remind the committee that we don't currently have a senator, so we can't vote ultimately until they're back, just as a awareness.
Thank you. There are senators nearby. If we get to the point where we're ready to have a vote, we can summon them. All right, let's take a break and try to be back in 5 or 10 minutes. Okay, thank you. Okay, welcome back, committee members. I did want to ask Mr. Legee to join us one more time. I guess there was a question about funding, a funding mechanism, and I just want to make sure everyone has the same information.
Should I introduce myself again?
So there's a question about, this would be a one-time award of funds, and there was a question about your ability to, use all those funds during the allotted period, or whether they would lapse to the general fund, or tell me about how that would work if the whole $1.5 million wasn't expended during that period.
Is the question whether we're concerned about the time frame and the lapse and sending funds back to the general fund, or is the question kind of the technical elements of would it go back to the general fund?
I guess I'm asking if the agency would prefer the flexibility to continue to spend down beyond that time period in terms of just the one-time funding.
Gotcha. Yes, I think we do have some concerns. There's a lot of variables here, I think, with any new program, as we look at kind of marrying that up with existing resources and staffing and other things. So, and then looking at some of the project types here, I'll say that a lot of the current project types are infrastructure. They're adding camera systems. They are working on access controls, maybe putting in additional lighting and parking lots, things like that. Just based on the availability of contractors and equipment and resources and things like that, those timelines can be pretty extended. The federal program has a 3-year period of performance to accommodate those timelines. So we are concerned that in kind of a single fiscal year, spending down that entire pot could be a bit challenging and could drive ultimately what projects are ultimately fundable or not fundable based on how much time we have.
Okay, thank you for clarifying that. Eli, how would we change that in the bill?
And so with one-time funding, the general practice is at the end of that fiscal year, the unspent funds would revert back to the general fund. There is language that we could put in, and you've seen this sometimes in our budget discussions periodically. There is carry forward language that allows at the end of that fiscal year, a fund, in this case, this fund, to carry that balance forward to the next fiscal year. And so you could add this, I'll have to double check where exactly you add that, but you could add language indicating the intent is to allow that to be carried forward. And so it would be different than ongoing funding where each year this money is appropriated. It would be this one-time funding of the 1.5 million, but allowing for MEMA to use that funding beyond that fiscal year deadline.
Okay,
And I
thank you.
apologize, I don't have that language in front of you today, but it's language we've used before for other funds like, PDS, for example, allowing carry forward of funds.
Okay. Any questions about that, committee members? Not seeing any. All right, thank you. Oh, actually, Representative Lee, did you have a follow-up?
Well, one of the amendments that we had was a portion of the allocated funds may be used in the main emergency management agency for program administration. And I thought that was sort of to scoop up any funds that aren't used for grants could be used for project administration for this one-time expenditure. Am I understanding that correctly?
I think the language, as I understand it in the amendments, for kind of management and administration costs. So for us to adjunct kind of staff time. So we have grant managers and grant staff that are working on federal programs now to kind of supplement their time to work on this new state program, which would be more upfront and not kind of at the end, if that makes sense.
Any other questions? Okay, not seeing any. Thank you for joining us again. Committee members, any additional discussion or a motion? Representative Pugh?
Thank you, Madam Chair. I'll make a motion to frame any additional discussion. I would move ought to pass as amended, the amendment being the yellow sheet here. And in addition, that language you just referenced, Eli, about the allocation of the funding.
Thank you. Is there a second? Representative Sinclair? Any discussion? All right, looks like the committee's ready for a vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
No.
Representative Henderson votes no. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross.
Yes.
Senator Talbot Ross votes yes. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin. Representative Caruso.
No.
Representative Caruso votes no. Representative Dana, I'll recall the absentees. Senator Hagan. Senator Hagan is absent. Representative Babin. Representative Babin is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 8 members voting in the affirmative, 3 members voting in the negative, 3 members are absent, and that is the vote of the committee.
Thank you, Supi. And what is your report?
On not to pass.
On not to pass. Is that the same for everyone? Okay. All right, thank you, everybody. Committee members, our next work session is not scheduled until 2:00. So we need to wait a few minutes. Eli, is there anything that we could get done during this time period while we have a little bit of a gap? No. Okay, so we will resume the committee meeting right at 2:00. All right, committee members. We'll get back to our work. Okay, we're going to open a work session on LD 2163. This is an act to improve the response to complaints by victims of crime and enhance victims' rights. And I know we have an amendment. Janet, are you able to start by walking us through?
Certainly, I can walk you through it, but otherwise I defer to the folks behind me. But this is similar to the sponsor's proposed amendment that you had at the work session last time, with some revisions. So if we start on the first page, anything shaded is different from the original bill. So the sponsor had proposed adding some language that would clarify that there's a process in the Department of Corrections for victim complaints, and that this victim complaint process that's being established by the bill wouldn't apply to those. So I slightly rewrote it to make it clear that any allegation by a victim of violation by the Department of Corrections itself or one of their correctional facilities or services, the Office of the Attorney General would inform the victim, you need to go through the Office of Victim Services in the Department of Correction, but all the other types of victim rights complaints would stay with the Office of the Attorney General. So that's the first page. On the back of the first page, so page 2, there's language that was in the original bill and in the sponsor's proposed amendment talking about what happens after the Attorney General investigates the complaints, and that they can make recommendations to one of these authorities. And authority is defined earlier in the bill as a governmental entity that has obligations for victims' rights. And so they can make recommendations, and then within 30 days, the authority gets back to them and explains whether they adopted the recommendation or didn't. And I just slightly reworded some of this language in a way that made more sense to me, which is maybe more of a me problem than anyone else. Subsection 6 was something that the sponsor proposed adding. So this was not in the original bill, that she proposed adding at the first work session. And this is to create confidentiality over the records that the Office of the Attorney General has when it's conducting these victim rights investigations. And originally it was just in one block. So we broke it out into subparagraphs so you can see exactly who would still be able to access these records. So paragraph A is someone that's necessary for the office to conduct the investigation. Paragraph B is a state agency if it's necessary for the state agency's statutory functions. Those were in the sponsor's proposal before. Paragraph C is a criminal justice agency if necessary for the administration of criminal justice or the administration of juvenile justice. I forgot one word there. That's my error, no one else's. And the definitions that are cross-referenced there, that was a recommendation from CLAC to make it very clear what you mean by administration of justice or criminal justice. So we put in those definitions that cross-reference existing laws that spell all of that out. Paragraph D was also a suggestion by CLAC, which is to make it clear because this is an investigation conducted by the Office of the Attorney General. That is an agency of the state. So the state has constitutional obligations under Brady Giglio to disclose potentially exculpatory information to a defendant. So that provides for that disclosure to occur if necessary. And then the community-based victim services provider was already in the sponsor's proposal last time. So we just broke it out a little more clearly row by row, mostly because when you add all those definitions, it really cluttered up the paragraph. So it felt better in breaking it out in a list. The rest of that page was all in the original bill. On page 3, in the middle of the page, section 5, this was a proposed amendment that the sponsor had at the work session, but I'm just going to remind you about it, that the proposal that she's putting forth is that a person who's a victim, if their records are subpoenaed as part of a criminal proceeding, not any proceeding, then they would have a right to notice of that through this victim's notification process. So that's just clarification language. In section 8 of the bill, this is related to that right. This is what happens with that right. So the victim has a right to timely notice. The language pursuant to Title 17A, Section 2102, which is cross-referencing up to Section 5 that we just discussed. That was added. This, I accidentally wrote CLAC recommendation. This was actually a recommendation from the main judicial branch. They wanted it to be very clear who is required to provide the notice, and where Section 5 is in the statute is a notification obligation of the prosecution office. So that just makes it clear this isn't some additional notice. This is the notice that you get from the prosecution's office. It's not that the court has to notify or some other party has to notify. And then again, it tells you that you can then be heard about whether that subpoena is appropriate or not for your records if you're a victim. In section 9 of the bill, this was the provision of the bill that talked about your right as a victim to be represented through an attorney if you had one. It's not a right to an attorney at public expense, but if you've retained an attorney, you can be heard through the attorney. Or if you want to be heard through your victim witness advocate, you can be heard through them as well. You don't have to personally speak. CLAC had asked for clarification that that's only about when you have a right to be heard in court. It's not creating some new rights, and it's not that you have, well, it's basically about your right when you have a right to be heard in court that you don't have to personally speak. You can speak through your attorney or the advocate. There were also some concerns, though, that CLAC had that the way the bill was written, it said that then you couldn't be treated any differently as a victim because you'd invoked your right to speak through an attorney. But there are rules of professional conduct that require attorneys who know somebody else is represented by an attorney in a matter to speak through that attorney. And so that is slightly treating the victim differently. You're saying, I'm not going to talk to you directly. I'm going to talk to your attorney or get your attorney's permission to talk to you directly. So we added some language to clarify that because CLAC thought that was important to be very clear about. On the back at the top is just another statement clarifying that this right to speak through the advocate or through the attorney is when you have a right to be heard already in court, not an independent right that's created. And then the summary is just updated. Now, if this were written as an amendment, the summary is not going to start all over. It would just tell you exactly what's changing. But I think it's really helpful the way they've done this so you could see what the bill would look like in the end if everything was integrated.
Thank you, Janet. Senator Hagan.
Thank you very much. I came in late, so does this replace the whole other bill?
So this is sort of a gussied up version of the sponsor's proposed amendment from the first work session.
Yeah.
I use that phrase for you, Representative Lee, to incorporate some of the proposals from the Criminal Law Advisory Commission and a recommendation from the judicial branch.
So I can delete the older one? The older version?
Depending on which one you like better, that's really up to
Okay,
you.
I like yours better.
It's not mine. It's a joint effort.
Senator Talbot Ross.
Thank you. Thank you,
Oh, sorry about
Thank you, Madam Chair.
Can you put your light on, please?
Thank
you.
Thank you, Madam Chair. I just wanted to make sure I understood CLAC's points and where they landed in this amended version. So a simple question is under 6 confidentiality. 6E to a community-based victim services provider. I'm not finding that is this CLAC's response? So I'm just trying to figure that.
B and D are what I tried in my inartful little drawing there to show we're from CLAC. E was already in the sponsor's proposal from last time.
Okay,
That had already been there.
So what, is there something in here? I'm thinking now about the law, not about the individuals who comprise our community-based victim service providers. Is there anything in the law that then holds them to some standard of confidentiality?
Yes, and that was handed out at the last work session. So attached to the bill analysis, it's actually part of the stapled bill analysis, are the laws about confidentiality of statements
Okay.
made to those folks.
I didn't want a loophole there. Thank you. And then, in Clark's, salmon colored response, it says, under section 2, Clark recommends that the purpose of the complaint process be clarified. It looks like that's what we're doing. In order that it not be misunderstood as a vehicle to challenge charging, sentencing, and other discretionary decisions. Is that what these clarifications have done? Because I am extremely nervous about that particular piece, that
I-
there could be, I'm not saying there will be, but the balance of rights within that context. I just need to be assured that the balance of rights within that context is actually what is in the bill.
So that language, that recommendation has not been implemented in this amendment, but you could certainly direct me to add language to clarify that further. So I wasn't asked to put that in, so
Yeah,
it's,
because
but it absolutely can be added. It's up
if
to you.
I can manage to get, I'm nervous about that piece. Very nervous about establishing a mechanism that could be, I'm not saying it would be, or people do, could be misconstrued as a vehicle for challenging, charging, sentencing, or other discretionary decisions. That feels like a very gray area, and I'm nervous about it. Thank you.
Other questions for Janet? Representative Lee?
I'm gonna try to keep this to the Janet part, but it's probably a two-part question that requires someone else to answer it as well. I'm trying to understand how the first sentence of section 9 is a statement of something that's different from the status quo. Are you understanding that there's something that precludes a victim from hiring an attorney and that attorney being present for court hearings at which the victim is entitled to speak?
I don't practice in this area, so I don't know if judges deny victims the right to speak through the attorney rather than speak personally. But it's my understanding that the point is, in case there's confusion, this clarifies that.
Representative Henderson?
Thank you, Madam Chair. Good afternoon, Janet.
Mhm.
Page 2, paragraph 6, the confidentiality piece, would that require a full review?
Yep. And that's why in your original bill analysis, you had the purple sheet, and I put a little note to myself. Needs a full review if you vote for it.
Okay.
So
Thank
we
you.
have the rubric ready to go if you vote for it.
Representative Caruso?
Thank you. Thanks, Janet. So is everything else that Clack asked for in this with the exception of what Senator Talbot Ross mentioned?
Just let me reread quickly. So there are suggestions other than the one that Senator Talbot Ross pointed out for section 2 have been adopted or incorporated as far as I understand it. I can't speak for Clack, but it looks to me that way. They did have different concerns that weren't necessarily suggestions. So they had a concern that requiring prosecutors to notify victims of these subpoenas of records could create some additional burden on prosecutors. That wasn't addressed, but they didn't suggest having somebody else make the notification. So I don't know what more to say about that. And then section 8, I think one reading of section 8 of the Clack report is it's possible that victims wouldn't need to be notified of and invited to these hearings about subpoenas of their records if everybody was following the law as it currently is stated. Now, I am not suggesting that the victim advocates would agree with that statement, but I think that could be one interpretation of their report. But they didn't recommend that you take that out, as far as I can see. They just made some observations that the rules of criminal procedure do require a rigorous review there, and maybe that's not happening right now.
Could you put your light on, please, if you're here, Mark?
So like their statement, this is not a criticism of the bill, rather education of practitioners and courts might be a possible alternative.
Right. And it's not that what the bill is proposing should already be happening. I think what CLAC is saying is Rule 17A, the Rules of Unified Criminal Procedure, require this additional level of scrutiny when you're trying to get certain types of otherwise privileged information through a subpoena. And maybe that additional scrutiny isn't happening appropriately, but what the bill does is say that the victim can be the one making that argument, which we had testimony that courts aren't allowing the prosecutor to make that argument, at least in some areas of the state, and the defendant, if they're the one seeking the records, is not going to make that argument. So that argument isn't maybe being made. And it's not that the prosecutor wouldn't, they aren't being allowed to.
Follow for Janet.
Okay, one more and then we're gonna go to someone
So
else.
is that something that we could, as a committee, recommend or encourage them to do instead of changing the law, but just encourage them like to do just this, do what you're.
So you would have to identify who you want to do extra training. I think you could absolutely do that. I've heard concerns from various different people about ordering the judicial branch or certain folks to do training. But there's nothing that would prevent you from doing that.
Representative Lee?
Sorry, I'm gonna giggle about that last part. The notice that we're talking about in section 8, as I understand it, it doesn't come with the issuance of the subpoena. It comes upon the court noticing a hearing on that subpoena. And so I'm just playing out a scenario in my mind. Someone requests, defense attorney subpoenas the records of a police officer. But the police officer and the district attorney's office don't object to the subpoena in any way. So, and then they give them the records and they deal somehow with the victim. The victim wouldn't receive notice in that instance unless there was a hearing scheduled on it. Am I understanding correctly that section is drafted?
I think your point is a good one, but maybe not the example, because it's supposed to be the victim's own records. But I think if the rule is followed, if we have Rule 17A, I gave it to you with the bill analysis. It's on the white paper that's stapled. If the rule is followed, and we look at subsection F, if it says if a party or the party's attorney knows that a subpoena seeks the production of documentary evidence that may be protected by a privilege, confidentiality protection, or privacy protection under any law, or the main rules of evidence, they should file a motion in limine before serving the subpoena. So that would mean you set this for a motion. So that should be happening, and this would be the motion you'd be getting the notice of, is my understanding of what's going on. Now, if that isn't exactly what you want to say, we can change it, but that's my understanding.
Okay, Representative Lee?
I get that, but the way it's presently worded is any record about or concerning the victim, which seems broader to me than the victim's own records.
I see what you mean.
Because any crime, any records that would be relevant to criminal conduct would be about or concerning the victim, if they're the victim of that crime.
Yes, so that's what section 5 says, and then there's like examples in section 8, and maybe those examples need to be in both places because they make it seem more about the victim's own records, right? So it's a medical record about me. It's not technically my record, but it's about me, so it's about victim. But it's something over which I would normally have confidentiality protection.
Go ahead.
And now I understand what CLAC is saying, because CLAC is saying if it is indeed that victim's record, right, their actual medical record, then that we should already be dealing with that, right? The motion of elimination should already be there. That's where I've been getting caught up, though, is about or concerning seems broader.
Yeah, so it may make sense to put that limiting language in both places if that's really the type of record you're talking about.
Representative Sinclair, your hand was also up.
I was just going to try to help focus on the about or concerning, which feels far broader than anyone hopefully actually intends.
Okay. Representative Henderson?
Thank you, Madam Chair. So let's say hypothetical scenario, we have this language about or concerning narrowed down to focus, I think, on the intent behind it, which is that if the victim's phone records, like specific phone records or medical records are subpoenaed, how many court proceedings are we talking about here, or potentially talking about where the victim would have the right to notice? Is this like just a single court proceeding, or would this be multiple if, say, a continuance is filed, or if there's I mean, is there like multiple court proceedings that this could impact? Or did I
think
explain myself correctly?
You probably didn't. I might have just misunderstood, but
Mhm.
the way I envision this is you have a criminal case going on. There's somebody who's the identified victim in that case, or alleged victim, however you want to describe them. They already have rights to be notified of plea agreement, the time and place of the trial, the time and place of the sentencing. All of those rights already exist. This would be adding a right that if records about them to be defined are being sought in a subpoena, they also get notice of that. So it's not, I don't know where the continuance would come in, because they already have rights to all of the other types of notice that's already current law. This is just an additional notice about this dispute about whether records about them can be turned over from one party to, or be subpoenaed from the holder of the records, like their doctor or their phone company.
Right.
I guess there could be multiple subpoenas issued. That might lead to multiple hearings, but I don't know that it's the one that's gonna be multiple notices about one subpoena, but there might be multiple subpoenas.
So I guess then after your explanation, my understanding would be that victims given an opportunity to be heard at any criminal hearing or criminal court proceeding. Is that because a subpoena might be issued at any point during the process?
It's only any criminal hearing or criminal court proceeding concerning a subpoena. So it's not once I'm identified as a victim, no matter what other criminal case is going on. I don't get notices about all of those. It's
Right.
just in addition to any notice I'm already required to be given by law. If there's a hearing or proceeding about a subpoena of my records, I get that notice.
So I guess that brings me back to my first question. Would that be if there's one subpoena issued or one subpoena put in, it would be one court proceeding. There's no potential for there to be multiple court proceedings on one subpoena.
I'd rather defer to somebody who practices criminal law to answer that. I've never dealt with that in real life.
Okay, that's fair.
I think Andrea Mancuso might be able to answer your question, but let's first see if there are any other questions for Janet. Okay, Andrea, can you join us?
Good afternoon, Andrea Mancuso from the Maine Coalition to End Domestic Violence. I just want to offer, I think there are also people sitting around the horseshoe that could answer that question. But the court process already calls for 2 court proceedings. The defense attorney who wants to, it's usually the defense attorney who wants to subpoena these medical or mental health records has to file a motion asking the court for the subpoena, to approve the subpoena. So that's one court proceeding. It's already scheduled, regardless of whether or not a victim has a right to be heard. Then if the subpoena issues, the records are provided to the court for an in-camera review, and a hearing is scheduled to determine what, if any, records are going to be released or access given to, and under what circumstances. So for this collection of records, my understanding is there's already 2 proceedings that are scheduled to address this desire. And so what the ask is to make sure that the victim knows what's being addressed at those two hearings and has an opportunity to be heard. And ideally, under the victim rights statutes as they currently exist, a victim would already be being given notice about the court date because a variety of things could happen at that court date. This is asking to make sure that they know that a subpoena for their personal records is being addressed at that court date and that the court has to give them a right to be heard, right? So if at the motion hearing, the issues are whether or not the defense attorney, I'm going to use the defense attorney as example, the defense attorney has set forth enough in the motion request to meet the standard that's already outlined in the rule. We're not changing that. As to whether or not the subpoena should issue, like scope of the subpoena. What's the scope of the subpoena that should issue, if any at all? The second proceeding would be an avenue for the victim to be able to say, make a request for a full copy of the record not to be given out to anybody. Maybe we do like what we do in DHHS proceedings, and the parties are required to come to the courthouse to review the record as opposed to giving over a copy of that sensitive information. So to your question, I don't think it's creating court proceedings. It's just allowing the victim to have a voice in them.
Yes, go ahead.
Yeah, my concern wasn't that it was creating another court proceeding. My question was, because it's not only a right to notice, but it's a right to be heard. So if there are multiple court proceedings, are they now being offered a point to be heard at every single one of those court proceedings?
Yes.
So notice of it as well as it, and is statutorily, is there anywhere that, or even just precedent set by the courts that restricts the amount of time that the victim can speak before the courts can be heard?
The court would have discretion over its docket in that way, right? To say, I'm not going to give you 40 minutes to stand and be, Abraham Lincoln with the Gettysburg Address. Under the statutes, and this doesn't seek to the paragraph, section 9 that responsive to the CLAC's recommendation is, I think maybe the updated language going to address your concern, Representative Henderson, in that every court proceeding doesn't build into it now a right for a victim to be heard at every court proceeding. It's to be heard only at those for which a victim has a right to be heard, which is currently at when a plea is accepted and at sentencing. And then we're additionally asking to be heard anytime the court is considering a subpoena for these types of records.
Okay, thank you.
And just so you know, that summary of where the right to be heard already exists is on the front of the bill analysis. Thank you.
Just one moment. Let's see if there are other questions for you. Representative Lee?
If we were to narrow up that language dealing with, I'm forgetting what the language was exactly, but about or concerning that victim, would you have an issue with that?
No, I think you would be moving the ball so extensively, even if you just noted medical or mental health counseling or treatment records, educational records, and cell phone records.
Go right ahead.
So those are the ones that are already covered by 17A.
Medical and mental health records are covered unless, so the language in the court's rule is, specific.
Privileged or
and specific.
protected.
Privilege, confidential protection, privacy protection under federal law, Maine law, Department of Health and Human Services, Maine rules of evidence. I don't know if cell phone records would fall under there. But the cell phone records, I think, is an important one. It's also where we've seen the courts most willing to push back on broad requests in response to victim motions to quash.
And
So
there are federal laws and state laws about accessing either location information or the content of communications on electronic devices. So law enforcement access to that. And so there are some protections already in the law. I would think that they're covered here.
So if we specifically listed those particular documents, okay.
I would be content with that.
Okay.
Andrew, where is that list?
It's in the court rule, which I think Janet gave you a copy of in her bill analysis. It's Rule 17A. It's a rule of criminal court process.
So that's the type of records that are privileged, but I think the actual list that we're gonna move is already in section 8 of the bill. So if you look in section 8, that's where it says.
Yep.
You have right to notice and then to be heard, and it tells you all the kind of records, and that's just not mirrored in section 5. So I think Representative Lee was saying these need to match. It's my interpretation.
Someday there will be a record that is not in that list that a victim is concerned about, but the ones that we have heard thus far over the last couple of years would fall on that list.
Okay, thank you. That's helpful. Hold on, more questions. Representative Sinclair?
Thank you, Madam Chair. Good afternoon.
Good afternoon.
It's good to see you again.
You as well.
So I had asked a question during the earlier, either work session or during the public hearing. I think I asked it of you, and I'm going to recall my recollection of your response, and maybe you'll tell me if you were right. I had asked whether the intent was that the victim have a voice regardless of what party is looking to access those confidential records. And I believe I received a response in the affirmative. Was that you?
I don't
Or do you
remember if
agree
it
with that
was-
response?
I don't remember if it was me, but I would be supportive of a victim being able to claim privacy over their records, regardless of who it is that is trying to obtain them.
I would
Because if
too,
a
but the way this
prosecutor
is.
Excuse
has
me, let's not talk over each other. Nope, you please finish your answer.
If a prosecutor has them, they potentially become, in most circumstances, I would think, discovery for a defendant, right? So if we need more language to accomplish that, the intent here is to give victims agency and voice over records that they have a privacy interest in a process in which they are not a party. I will tell you, I have worked with victims who the person who has harmed them has been charged, and there's a criminal justice process to which they're not a party, is going forward. And if you asked them what their preference would be, their records being exposed or the criminal justice proceeding moving forward, they would choose to keep the privacy of their records over having the criminal justice proceeding moved forward. And I think any victim services professional would tell you that some victims would hold that perspective, and I think they have a right to hold that perspective.
Go right ahead.
The reason why I asked the question is because the language as drafted, and I don't know if you were the one who drafted it or if the sponsor was, the language as drafted only deals with confidential information that is sought through subpoena, but it doesn't in any way touch on the AG's and all other prosecutors' power to get that exact same confidential material only through the Title V powers, which are not subpoena.
I would support an amendment that does the same thing for anyone in the criminal justice proceeding obtaining their records.
Thank you.
I thought they had to get them through subpoena too. What are the Title V?
Could you put your mic on, please?
The way I read 200-E, it's just they have to send a writing.
Okay, 200-E. Thank you.
Yeah.
Other questions for Andrew Mancuso? Yes, Senator Talbot Ross.
Thank you, Madam Chair. Can we go back to CLAC's review of the bill and where it says, section 2, they recommend that the purpose of the complaint process be clarified in order that it not be misunderstood as a vehicle to challenge charging, sentence, and any other discretionary decisions. Is it possible to get some language so that there is some assurances within this new process that what CLAC is asking for can be accommodated?
I will tell you that the intent is not to give that. I don't read anything in here. So I went back in and reviewed that in light of, and it has the sort of, right, the purpose of the process is to further uniformity, efficiency, compliance with current laws around access to justice. That's sort of in paragraph 2. I don't have any objection, I guess, with a clarifying sentence that it's nothing in this process may be used to challenge a charging or a sentencing decision pertaining to an individual case. I think the process is meant to influence discretionary decisions of the state writ large, right? How an office is choosing to implement policies and practices around victim notification and victim access to justice generally in their office, I think is very discretionary. But I think I hear your concern as we want to make sure that this process is not baking in a pathway to walking back charging and sentencing decisions. That's not its intent. So if a sentence in there would be helpful to that effect to move this forward productively, I certainly have no objection to that because it's not the intent of the process.
I appreciate that answer, and I would ask that perhaps we think about that language and be able to adopt it, and then
Perhaps Janet could give us some.
I very much
assistance.
appreciate you engaging in this part of the discussion. Thank you.
Representative Lee.
Just want to make sure we have a meeting of the minds on section 8.
Yes.
So I'm looking at the language. And my vision of what it would look like would be something to the effect of deleting everything from any in the middle of the paragraph to limited to. So just delete that portion and essentially insert their medical or mental health counseling or treatment records, educational records, or cellular telephone records, and then mirror that list in section 5.
Can I read it back to you to make sure? Because auditory processing is not my. A victim has the right to timely notice pursuant to Title 17A, Section 2102, and must be given an opportunity to be heard at any criminal hearing or criminal court proceeding concerning a medical or mental health counseling or treatment record, educational.
No, a
Concerning a
subpoena
subpoena for
issued
any.
for their medical or mental health counseling or treatment records, educational records, or cellular telephone records.
I think that would accomplish the goal.
Thank you. I just wanted to make sure, yeah.
I think that would accomplish the goal.
Are there other questions, committee members, for Andrea Mancuso? I think you're free to go.
Thank you.
Thank you. Committee members, are there any further questions or discussion, or do people want to take a break and mull it over for a few minutes? All right, any further questions before we take a break? Okay, not seeing any. We will go and, oh, sorry, the bill sponsor would like to join us for a moment. Please come up.
Hi, Lori Graham, sorry, House District 131. I just want to say I agree with the conversation and the direction I think in which the committee's going and with everybody's feedback. But if you do not see me here after your break, it's because you've heard me coughing. I have an ENT appointment in Portland that I've been waiting 7 months to go to. So it's not, my absence is not intended to be that I don't have an interest in this bill. I'm very interested in it, but I do have to go to Portland, so I apologize.
No problem. Drive carefully.
Thank you.
All right, let's take a break and come back at, let's see, how's 3 o'clock? Great. Okay, committee members, let's return to the horseshoe, please. Thanks, everybody. All right, we've been on a break during our work session on LD 2163. We've had an issue surface that people want to explore, and unfortunately, we do not have the right people available to discuss it and provide further information at this time. So I think we probably should table for today. Senator Talbot Ross.
I was just, if you're ready for a
Yep.
motion to table.
Okay. And let's try by a show of hands in favor of tabling. All right. Thank you, everyone. Did you get it, Janet? That's unanimous among those present. And we will get this back on the schedule just as soon as we can with the right people in the room to answer questions.
So are you asking me to make this happen? Who do you want in the room?
Yes, I mean, I think we need Shira Burns
Okay.
or her designee, someone who can speak to the prosecution side.
Thank you. And this is about the Title V 200.
Correct.
Okay.
That's exactly right. All right. Tell us when you're ready. So that's the end of the work session on 2163. Hi, Eli.
Hey.
Committee members, I'm going to recognize myself. This is a discussion on LD 1821, which was an act to ensure responsible business practices by licensed firearm dealers. I would like to ask the committee's permission to reconsider a portion of the bill. I was not on the prevailing side, so I cannot make that motion, but I can share what I'm thinking about if that's of interest before we vote. Sure.
Having voted on the prevailing side, I move to reconsider.
All right. And we'll try by a show of hands. All those in favor? All right. Thank you, everyone, for that courtesy. I really appreciate that. You'll recall there's a portion of the bill that creates a Class D crime in the event of a knowing violation of the statute if it were to go into law. And upon further reflection, it started out in the bill as a Class C crime, then we moved it to a Class D crime, and I would like to move it to a civil penalty. I don't expect that to really change anyone's vote on the committee, honestly, but it is just sitting better for me. And so I am interested in making that change. I did just see Lieutenant Cassavant in the hall, who has some information he'd like to share for us in connection with that consideration. Senator Hagan.
Part of the bill?
Pardon me? Yeah.
The portion of the amendment that we're discussing, it's going to be on page 4 of that yellow amendment. It's false certification penalty. Correct?
I don't have it there. Yep, false certification penalty
That's the one. And so
under 507-4. Lieutenant Cassavant has some, if you don't mind joining us, you shared that you had some relevant information that might complicate matters even further. But we'll hear the information and see what to do about it. Welcome.
Thank you. Just in the last session, when you were going back and forth on the revisions, the first thing that came to my mind when I was trying to work through it was a potential conflict with existing state law on an aggravated forgery charge, which is a class B crime, one level higher than what you had originally proposed. And I guess really what it's going to come down to is the language of the final bill. But under 702, paragraph 1D, it says a public record or an instrument that filed or required or authorized by law to be filed in or with a public officer, public employee. And I think this document would be that, given the law, potentially. And so under subsection 1, it says person is guilty of aggravated forgery if with intent to defraud or deceive another person or a government, he falsely makes, completes or endorses or alters a written instrument or knowingly utters or possesses such an instrument, and the instrument is, and that's when I go into that piece down there. So I think there's a potential that that could be a conflicting piece, depending upon how somebody smarter than me views that form that you author into law that's required by gun shops to certify and send into the state as a potential conflict there.
And committee members, this is on page 107 of your red books, for those of you if you're looking for it.
Yes, please, Representative Lee.
You're calling it a conflict, but I mean, it just means that there's already an existing crime that someone could be charged under if they were to forge those documents. Is that what you're saying?
Yeah, and I guess from an enforcement perspective, I don't want to have two laws on the books that have two drastically different penalties that are in direct conflict with each other. And there's a potential that it could be an unsworn falsification too, depending upon the manner in which we kind of view that and what that statement is, which also would not be a civil penalty.
Representative Lee.
Yeah, I think I'm just taking issue, and I'm being a little pedantic here, but I think I'm taking issue with the notion that it's a conflict. It's just sort of we'd be adding a new crime or civil violation that would be sort of a lower offense, right?
You could,
for
but
the
as-
same activity, which we do all the time, right?
For the same conduct, we have lower.
We charge the different crimes or different violations for the same conduct all the time.
I guess I'm not sure I just want to make sure I understand. I'm not trying to be argumentative with you. I just don't know where you're going with that as far as what you mean.
So
You have a specific,
if someone commits domestic violence assault, we charge them both with domestic violence assault, and lesser included in that is assault.
I've always only charged them with assault. And now that might get pled out in court
Right.
to that, but that's an entirely different process of what happens in a judicial process versus what happens in the field.
Give me a second to think of a better example. I
course.
think Representative Sinclair would be the best one to think of that example, but multiple crimes charged for the same conduct.
Eli, did you have a
I mean,
comment on
the way
this?
that I look at this is similar to the DV assault. Assault is like an OUI and a driving to endanger for something that's pled down, or also charged with reckless conduct as kind of the over blanketing. I think that's.
Representative Sinclair.
Madam Chair, I don't normally do this when I have to step out of the room. I apologize for having been out. Representative Lee indicated I should be able to answer something. I don't even know what the underlying question is. If whoever asked it would be willing to restate it, I would be grateful.
Yep.
So, it was suggested that there's another crime that could be charged here, aggravated forgery, that would be a class B. And it was expressed that a new crime that would have a lesser grade, I think we made it a class D, for the same conduct would be a conflict. And I was taking issue with the notion that's a conflict because oftentimes there are similar or different crimes that can be charged for the same conduct. And I was trying to think of an example of that, and one was not coming immediately to mind that wasn't just a lesser included offense.
Why don't you mull that over for a second? Representative Poirier's been waiting.
Thank you, Madam Chair. Just along with what you're saying as far as like the aggravated forgery and such like that, is it potential that, I mean, there's this one, whether it's falsification on the paperwork or what have you, could they be crimed? They be charged with multiple crimes for that same incident? Could it be charged under this class D and then also under this class B? Or would it be some might get charged with a B and some might get charged with a D? How would you envision that happening if there is a conflict in that?
No, I mean, I think that in the scenarios that we're trying to hash out here, if somebody commits an assault and in the process of committing the assault, the offense of physical conduct to another, something else happens that was also reckless conduct. Those are two different laws with two different definitions that you can't charge somebody for the same thing 6 different ways, right? There's gotta be clear delineation, or at least given my experience, but not being an attorney or a prosecutor. I don't think you can charge somebody for the same course of conduct for 2 different crimes with 2 different penalties. Now, could the prosecutors choose to go a different direction? They certainly could. But I think that as a law enforcement officer, you charge what the appropriate crimes at the time.
Yes, go ahead.
So just to understand that, so say it was a legitimate mistake, but state didn't like it. They may charge with that D, but if it was something that somebody knew they were filling that out incorrectly for whatever reason, that would be more likely to be a higher level charge.
Well, I think that that goes to the culpable state of mind in the criminal code, right? And there's elevations of charges depending upon what actually occurred as a result of that conduct.
Okay, thank you.
Welcome.
Representative O'Halloran.
I'm also not an attorney either, but when I'm reading this, where it says falsely makes a written statement, which is basically what's going to happen here, in my mind, it seems to me that the police officer would have discretion on which one they charge.
I mean, we always have discretion, right? As far as what it is you're going to charge or not charge. That certainly is something that can happen. I just think this is going to create confusion that we have a law in the books that makes a civil penalty of something that people know to be a felony level charge, which is what you had originally. It was a class C. The aggravated forgery, because it's an official document, is a class B crime. And I'd have to look, I threw the unsworn falsification out there. I'd have to look at that, or unsworn falsification, look at that very closely, but that could potentially be, depending upon how we view that document. But aggravated forgery is something that we see, it's commonplace, for sure.
Can I just say a follow-up?
Yep, go ahead.
So if you go in and you review these records and clearly they lied, like, they didn't do any of the training, but they stated, so that is not a mistake necessarily, right? So at that point, the law enforcement official could say, it could just write a charge for the B instead of the civil penalty.
I think you could, where you run into, where a prosecutor's probably gonna ask you a lot of questions is, why didn't you write them under the rule that's under this specific law? And you would then have that argument with the prosecutor as to why you felt it better was suited there. And then a defense attorney would come back and say, well, wait a minute, this law's on the books here that says this. The prosecutor would say, yeah, but it meets the definition of this here. And then the person that sits very high up on there in the black robe gets to decide one way or the other how they feel about, what would happen or what would not happen.
Can I just ask one more quick
Yes,
question?
go ahead.
Would there be precedents for the B where it's been long, basically it is a crime, it's the same crime,
Meaning
falsifying the information?
I mean, people have been charged with that, yes, and probably likely convicted of that over the lifetime of the law, I would suspect. I don't know exactly when that law went into statute, but it's been around for most of my career, as I can recall. Maybe the definition has changed slightly, but.
Thank you.
Are there other questions? Yes.
I guess I'm looking right in the section dealing with aggravated forgery. Aggravated forgery is not well, I mean, it it contains some other stuff. But it's not too dissimilar from criminal simulation. Like there's stuff you could charge as both forgery and Class E criminal simulation.
I'd
The
have to
same, for
look
the
at-
same conduct.
Yeah, I'd have to look at what criminal simulation is defined as.
And forgery itself, right? You have aggravated forgery, which is the Class
Mhm.
B.
But forgery is more towards monetary instruments.
A person is guilty of forgery if with the intent to defraud or deceive another person or government, the person falsely completes, endorses, or alters a written instrument or knowingly utters or possesses such an instrument. I mean, what I'm saying is there are multiple crimes that overlap, and that's not an uncommon thing for our statutes.
But then if you look at under what says instrument, it talks about monetary value of instruments, which again, I would lead back more towards money in currency or checks. In my interpretation.
Okay.
Are there other questions for Lieutenant Casavant? Okay. Representative Sinclair?
I didn't hear the part where the officer articulated objections to our having potentially several different charges that might alternately be brought for the same conduct. I would point out that sometimes that is a benefit, not to defendants, not to prosecutors, but rather to the process. If there's more than one possible charge that could reasonably be brought for the same conduct, that gives opportunity for the two parties to potentially reach agreement where they might not otherwise, particularly if we're looking at the difference between a Class B, which is almost always going to go to trial, and instead a misdemeanor possibility avenue for that same conduct. We do have some potential behavioral overlap between disorderly conduct and criminal mischief, for example. I set off a device, it makes a loud noise. That loud noise happens to cause some damage, either by dislodging something from the wall or through some other mechanism. If for some reason, those happen to be the same class, so there's not a hell of a lot, I apologize, there's not a lot for the two parties to debate about in terms of plea negotiations. But if they were of different class, that would give both sides an opportunity to find some middle ground if they chose to do that. And I haven't seen any harm to the system from there being that overlap and giving charging discretion and negotiation discretion.
I don't want to
Do you have a
make you go
response?
down this road for days at a time here. You guys have talked about this far, many times for sure. My feeling is that it's very clear in this statute, if you falsely file a document with the government, it is this charge. And you're saying if you falsely send a document to the government that you lie about is a civil violation. That to me is, we can argue the disorderly conduct and the criminal mischief, and I get that. I mean, they do have some similar patterns. But I think this definition is pretty clear that, if you lie on a document to the government and it's an official document, it's this. And we're saying, but not in this instance, it's only going to be a civil penalty. So that was my only, and I only bring that forth. I mean, you've already voted on this. You're now trying to lower it down to a lower class of crime, which is perfectly fine to do. But I just have that concern about potential enforcement down the road and confusion of anybody trying to investigate this crime more than anything.
Okay, thank you.
Thank you.
Committee members, any further discussion? It's a little unusual to have a caucus on a reconsideration on language review, but could we just take 5 minutes and we'll be right back? Senator Hagan?
So am I interpreting correctly in that your original intent was not to have it as a high class of crime, but now there's new evidence that already on the books, it could be a B crime, and we would probably have to figure out language to make it back down, or no?
I mean, I don't think we can change the existence of those other statutes, but this is, that's what I'm gonna go just process for a couple of minutes, if you'll indulge me. All right.
Can I?
Yes, Representative Poirier.
I just want to add on while you're doing
Yep.
your consideration that after we spoke last night, I did speak to somebody, one of my contacts at ATF.
Mhm.
And even if it is a lower civil infraction, if it's considered a willful violation of record keeping, so even if it's on this state level and a lower infraction, it would still be cause for ATF to remove their license.
Okay,
I don't know if that was part of your consideration, but I wanted you to know that information.
okay, I appreciate that. So we'll just take a 5-minute break and just quickly caucus. All right, committee members, we will resume our work session on LD 1821. I'll wait till Eli's seated. I'd like to move forward with my original intention to remove any reference to a crime in this bill and take it to a civil penalty. So I guess I make it ought to pass its amended motion along those lines. Do I do that? Or Representative Pugh, could you do it?
I'm sorry, Madam Chair, are you asking for me to make the motion or to second?
Could you make the motion?
Thank you.
I think that's better.
I'd be
Thank
happy
you.
to. I would move ought to pass as amended with the removal of the crime.
Is there a second? Representative Sato? Yes, Representative Henderson.
Thank you, Madam Chair. Does that motion also include with the addition of a civil penalty?
Yes, it does. Thank you.
Thank you.
Yes. Eli.
So with that civil penalty, what would the penalty be? A civil penalty with a fine of
$1,000.
$1,000. Great, thank you.
All right, is any further discussion? Is the committee ready for a vote or Representative Sato?
I guess I'll speak to what we've previously has come up in this work session, with the potential realization that creating a new certification could could trigger a Class B aggravated forgery. And I'm just in thinking about this discussion, we face a lot of bills in this building that create new certifications that record that to the government, that are not related to this specific policy area, that if those documents were falsified would also trigger a Class B aggravated forgery. And so I'll just share that this maybe is a consideration that we should take into account into everything going forward, or to remember that maybe this is something that in this case, we are providing an option for this specific situation with an FFL to allow them to be able to still possess a firearm if this is happening, if there's a falsification of a government document. And so for those reasons, I'll be supporting the motion and very fascinated by the discussion that has come up today.
Thank you. Any other discussion? Okay, let's go ahead. Oh, Eli?
And just as a point of clarification, my assumption is that the motion includes all of the amendment language from our last work session. And there were a number of bullet points that if the committee wants, I can read, but if you remember what you had voted on before, I'm assuming that that carries.
Representative Pugh? All right, I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
No.
Senator Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
No.
Representative Henderson votes no. Representative O'Halloran.
No.
Representative O'Halloran votes no. Senator Talbot Ross.
Yes.
Senator Talbot Ross votes yes. Representative Lee.
No.
Representative Lee votes no. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin. Representative Caruso.
No.
Representative Caruso votes no. Representative Dana. I'll recall the absentees. Senator Carney. Senator Carney is absent. Representative Babin. Representative Babin is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 5 members voting in the affirmative, 6 members voting in the negative, 3 members are absent, and that is the vote of the committee.
All right, thank you. And for the folks who voted no, is your report on not to pass?
Correct.
Okay. Is that everyone?
Yes.
Yes, okay. So ought not to pass. Thank you, everyone, for allowing me that reconsideration. I do appreciate it. Eli, do you have anything else for us today?
That is all that I have for the week.
Music to our ears. Can we have a motion to adjourn? All right, all in favor? Thank you.